Diane Donnelly, and I am with the Donnelly Group of Keller Williams Flagship of Maryland, and I run a small real estate team here in Annapolis. And today we are going to be talking to Tara Frame of Frame and Frame, and we're going to be talking about a topic that is one that a lot of people don't want to talk about, which is why we need to talk about it. And I hope it brings you the urging that you may need in order to get it done. And today we're going to be talking about passing away with or without a will. So Tara, if you would, just tell us a little bit about yourself, and then we will jump right into some questions.
Thank you, Diane. It's a pleasure being here with you today, and I'm always happy to discuss this topic and to educate viewers. So my name is Tara Frame, and I am an attorney with Frame and Frame. We have 4 offices, one in Pasadena, Annapolis, Stevensville, and Frederick. And my part of the practice focuses on estate planning, elder law, probate, estate administration, which is estates and trusts, basically wills, powers of attorney, and everything that goes along with that. I've been practicing for 26 years now, and it's really become a passion of mine to educate people about this subject because it's so important, and there's so much misinformation out there that people just don't understand. So, you know, I've really enjoyed educating people about their misconceptions.
Well, you know, I personally have had many conversations with you, Tara, about all kinds of topics estate planning wise, and you've always given us so much information and things to really think about and really to chew on, to say, what if this happened? How do you prepare? So I just really appreciate all the conversations that we've had offline.
Yeah, yes, definitely.
All good stuff.
Yeah.
So let's start, Tara, let's start with what does the word testate mean?
So testate means, when you die testate, that means you die with a will. So that is the opposite of intestate. So so if you die with a will, that is a valid enforceable will that's in Maryland. It requires that it be in writing, it be signed, and that it be witnessed by 2 independent witnesses. And that would be dying testate.
Okay, and then the opposite is dying intestate without a will.
Right, so when you die intestate, that means you do not have a valid will that's going to be what's called probated through the court or followed by the Register of Wills to distribute your money and property.
Yeah, and I want to dig into both of those. So what happens if a person dies intestate? So let me give you an example. Very recently, I had a friend's husband who passed away due to COVID, and they had a small child, and they hadn't done their estate planning yet. So he did not have a will. He's thinking, I'm safe, I'm in my 20s. And so he didn't do anything. What happens now?
So in that situation, when you have, that can be an unfortunate situation. So his estate will still, you know, unlike what many people think, the estate doesn't go to the state. It still passes to the family, but he doesn't get to choose who the executor is. He doesn't get to choose how it's divided. He doesn't get to choose if it's protected down the road for his children. So the law governs. As a surviving spouse, and if you have minor children, the spouse is generally going to be appointed as the executor. And if there's a spouse and minor children, then the spouse gets half of the assets and the child or children get the other half. Mm-hmm. So in that situation, that could cause a lot of issues. If there was anything, it gets a little complex, but anything jointly owned would go automatically to the wife. But if the husband had a business, if he had any bank accounts solely in his own name, if he had any cars or boats, you know, a rental property, anything in his own name, that would have to go through the probate process, and that would be subject to division pursuant to the law. So his wife would get 50%, but his minor children would get the other 50%. And the wife or someone else would have to obtain a guardianship in order to hold that money for the children until they're 18. So that money could not be used for household expenses or for you know, anything that the wife might need, because it has to be held in a restricted account for the children until they turn 18. And that's more than likely not what the husband would have intended. And that can be devastating to family finances if they had their assets separate.
Well, you know, if you think about that, so this young family has two people working. They have two incomes. They have a savings account, maybe not, a couple of dollars in the savings account. And she or he, the surviving spouse, may not even have access to be able to pay the bills because only half of the account is hers now.
That could certainly happen. Yes.
Mm.
Yeah. I mean, I had a situation with an older woman, so there were no minor children, but, you know, it was very tragic because this woman had met she was an au pair from Scotland. She came over when she was young from Scotland, married her husband who already had 3 daughters. But they were very young. And so they had been married for 45 years. She had helped raise these 3 daughters. You know, she treated them as her own. And when he passed away, their family home was only in his name and he had no will. So she basically had to divide. It was a little bit different because she gets, at that point, she gets a certain sum of money, but the other 50% had to be divided with the 3 stepdaughters. And they all wanted their share. They wanted their part of the money, and it tore the family apart. She couldn't afford to stay in the home because she didn't have the money to buy out the 3 daughters for her own house, basically, that she lived in for 45 years and that they had bought during their marriage. So she had to sell the house to pay them off, and then ended up, you know, moving to another state. But it basically destroyed the family, and she couldn't believe that these 3, you know, stepdaughters that she treated as daughters basically did this to her and put her in that position. And that's certainly not what the husband would have wanted for his, you know, 75-year-old wife to have to move from her home and basically give up half of her assets that she really needed to live on in retirement.
That's tragic. That's terrible. And stories, I'm sure you hear that all the time. I had a client who was pretty young, retired early, had a live-in girlfriend forever, you know, for like 116 years. And he retired and moved down to South Carolina to his dream place in South Carolina. Within the year, he passed away completely. He was completely healthy and just passed away very quickly. And she called me crying and she said, the family is not recognizing me as a significant partner. And she said that they weren't going to give her any of the money, although she's been with him for all of these years. He absolutely adored this lady. I mean, I remember saying, you know, I hope everybody gets to have the relationship that you have, but the family was giving her nothing. She walked away with nothing after being in a relationship with this man for, you know, probably 30 years. It was horrible.
Right, because under the law, she's not a blood relative, she's not a spouse. And if he had had a will and had left her, you know, a part of his estate or all of his estate, that will would have controlled and she would have gotten whatever he left to her. But without a will, it just goes by the statute, and the statute only leaves your assets to your descendants. If you don't have any descendants, meaning, you know, children, surviving children or grandchildren, then it's going to go back up to your parents. So that's a situation. I had a case recently, and this was heartbreaking. The son, he was young, he was in his 20s, but he had been married for 3 years, and he died unexpectedly, and the parents were devastated. Basically the wife was devastated, but she was from South America, so she went back there. But the family, the parents ended up paying most of the expenses, and the estate was divided among the wife that he had known for 3 years, and then the parents. But that was a really tough situation. Again, had he had a will, it would have made it a lot easier because everybody would have known what he would have wanted.
Right. Because people may know what he wants, but if it's not in writing, it doesn't matter what anybody says. So remember, I started at the top of this call, I said, I hope this gives you the urging to do what you need to do, which is to create a will for yourself. If you don't have one, get one. And I think it really, I mean, there's a lot of people who aren't getting married these days, and they're just living it with their significant others without a marriage. And that leaves you wide open. It sounds like that if you are not married, but you have been living with somebody, you have zero protection.
That's true. Yeah. So yeah, there are a lot of, in this day and age, marriage is not necessarily the norm. I mean, it is, but there are a lot of non-traditional families. There are families that they don't want to get married, but they have children together and they're still partners. We have the LGBTQ community that, they may not want to get married, but they're still partners for, 20 years. And unless people have a will or a trust, which names the partner as a beneficiary, then those partners they're not relatives, and they will not receive anything under the law. So they're completely disinherited. And that is generally not what people want. And they don't think ahead. They don't think about these things and what mess their family or their loved ones are going to be cleaning up when they're gone.
Yep. So now what happens if somebody does have a will, but there's some disgruntled person in the family who contests the will? What's that all about?
Well, if you have a will, you do have a certain period of time to object to the will. It's called caveating. You file a caveat. But you can file a caveat. Anytime there's an estate open, anybody can file, but they have to have grounds. So the only way to succeed is to prove that either one, the person was incompetent. So if they had doctor's records saying that this person had been diagnosed with dementia 5 years ago and the doctor had declared the person incompetent, if the law had declared them incompetent and had granted someone guardianship, or the other case, it's a little bit harder to prove, is if somebody is exerting undue influence on them. So if you have a very special person that maybe lives with them and is with them all the time, and they really exert undue influence on the person to get them to do something they wouldn't have otherwise done, and that's not a natural, there's just something fishy there, you can file on those grounds. That's really hard. I've had one case that went to court, but those are really tough cases to prove. So, it's hard to overturn a validly executed will.
Well, that's the purpose of it, right? Is
Yeah.
These at this date, when I'm signing this, here is my wish.
Right. And as long as the person, they know what they want, they're competent to sign, and that, it's in writing, it's signed and signed and witnessed, then it's valid and enforceable. And, you're not required to leave all of your children or your relatives, your estate, your property. You have the right. It's your money. It's your property. You can leave it to whoever you want. You could leave it to, a charity. Some people say, what, I'm not giving anything to my kids. They're spoiled. I'm going to give it all to charity. Or they have a child.
Warren Buffett. That's what Warren Buffett's doing. Can you imagine being their children getting not a penny from their dad?
Yeah, no. But, you have children who they haven't had any contact with their mother for 30 years. And then when mom dies, all of a sudden they have their hand out looking for a piece of the pot. And, if the mother had created a will and says, I do not want her to receive any portion of my estate, then that's valid and enforceable. They have no right to participate in the estate.
And if you have real property in a different state, does Maryland probate cover that?
No. So if you have property in other states, but if Maryland is your primary residence, your domiciliary, and you die in Maryland, then your initial estate, your primary estate would be open here if you have property here. But then you'd have to open what's called an ancillary estate in each state where you own property. So I certainly have clients who have, maybe they're residents of Maryland, but they have a house in New York because that's where they're originally from. They might have a house in Florida, a vacation house, and a house in North Carolina. And the best thing for them is to hold everything in trust. That would be my recommendation for that, because that avoids probate entirely, which probate is the court process of conveying and transferring property of a decedent to their beneficiaries. Then we can avoid that. But otherwise, we'd have to open a state in Maryland, one in New York, one in Florida, and one in North Carolina.
Wow.
So yeah, so the way to avoid that is you have everything in a revocable trust, and the trust technically owns everything under that umbrella, and you avoid all of those probate processes.
And you can do a will under a trust.
Right. So if you have a trust, you always have a will as well, because let's say there's a car you forgot to put in the trust, or there's a small bank account, or after you die, a lot of times you'll get health insurance refunds, or a homeowner's insurance refund, or tax refund, and those are going to be paid to the estate. So what happens is, we would open a small estate, and that passes right back into the trust, and then the distribution comes from the trust and the trust agreement. So it's a really nice way to consolidate your property. It's private, doesn't get filed with the court. It avoids the whole court process of probate, and provides asset protection, gives you a lot of control from the grave. So there's a lot of benefits to a trust if it's a right situation for a trust.
Yeah, we talked about a couple of those examples, and I have talked to people who said, I said, did you ever consider doing a trust instead? And they said, oh no, I don't have enough assets for that. So they think it's more a matter of, if you've got ample assets or a significant amount of assets, that it would make sense to do a trust. But if you only have a few things like this, this, and this, but that's not the case. There's a lot of other protections in addition to, high asset people.
Right. I mean, really, I have a discussion about trust with even a young family with minor children, because, who wants when you put everything together, the value of your house, your life insurance through your employer, your private life insurance, your investment account, your 401k, all of that, when it comes down to it, sometimes, they say, I don't really have a lot. And we start adding it up, and it's like $2 million. Like,
Yeah.
we're looking at $2 million to pass on. Do you want your 18-year-old to have $1 million in their hands if something happens to both the parents and they're in an accident? I certainly don't want my 18-year-old to have $1 million right, accessible. So, the way to provide protection for your children for, basically their lifetime, if you want to, is the use of trusts. So it is not just for wealthy people. It's not just for, you're rich and you think, oh, that's only rich people have trusts. Trust is really now for asset protection. It's to protect money and property for your children in the future or your grandchildren, and keeps it away from if they get divorced. It protects it from any future divorce, bankruptcy, judgments. So it's a great way to really protect your property and pass it on to your spouse, your children, your grandchildren in a way that really protects it from unexpected circumstances in the future.
I'm sitting here thinking, Tara, you and I have had so many conversations online, offline, about these kinds of things and the examples that we talk about and things that I think, man, I don't know. And I go through my head of, I wonder if my friend who is going through this, I wonder if they know about that. And then I hear people saying, I'm going to go do Zoom online, whatever that is, where they do the estate planning online with zero guidance, zero counsel, no thought-provoking questions. The crazy people. I urge you to talk to someone, Tara, preferably, we love Tara, about your estate needs, because you don't want half of your stuff going to someone that you don't even get to talk about. Like, these are what your wishes are. You've worked hard for it. You work hard for your spouse. You work hard for the kids. You work, diligently to get your wealth built up, and then whoops, nothing, it doesn't go as planned because you didn't do the will, or the will wasn't done to the extent that you needed it, or a trust would have been a better avenue. But that's why you have to talk to an attorney about this. Going online, this is not one of those things you go online for. Right. So what does a simple will cost?
Yeah, just to go back, I would say the old adage is you get what you pay for. So you're going online, you're going to get a form that you put your name and your kids' names in. It's going to spit the same one out pretty much for everybody. So that doesn't always apply, it doesn't apply to every family. But, I would say a basic standard will package with, with your wills, your powers of attorney, because those are important. We haven't even talked about those, but while you're alive, you need powers of attorney for healthcare and financial. You're probably looking at $1,000, to get all of that in place, knowing that you're protected, your family's protected, and to give you peace of mind. So it's so relatively nominal. And I've had clients, come into my office before with, their parents had really gotten everything in place. They had everything in order. I mean, usually it's with a trust, but their wills, whatever. And, you know, they said, oh, thank goodness that my parents thought of this ahead of time. It was such a gift to me. So, you know, I can really focus on grieving for the loss of my parents or my mother or father, and not be dealing with, you know, all of these unknowns and surprises and unexpected things coming up in their estate, because they had sat down, they had planned properly, and it really, you know, it is a gift to your family.
Mm-hmm. You know, my mom's getting older. She's 85 years old, and it's easier to talk to people when they're healthy than to do it when you're late, you know, when there's a sickness or an illness, because it feels like you're talking about something happening in a week or two. So, you know, I just encourage you to do it now while everybody's healthy, and it's not, you're not under pressure to do something because of bad news, right? That's not the time to do it. Do it while you're healthy.
Yes.
And then Tara, we're going to put your information below. I think everybody's able to see it now and access that information now. But is there anything else that we didn't talk about today that you want to talk about for in terms of wills?
Yeah, no, I mean, I would encourage people, just go to our website. It's frameandframe.com, and we have a ton of information. We have guides for all different phases of your life. So we have one for younger family estate planning. We have one for long-term care planning and nursing home planning. We have family protection checklist. So we have all kinds of resources on our website, and they're free. Just go to the website, download them, and there's tons of information that you will find helpful and useful, and provoke some questions to discuss with your family and friends, to make sure that, you know, you're protected and that they're protected, and that you know, you really have peace of mind knowing that things are going to happen the way you want them to happen when you pass. You're in control, not the state of Maryland or the courts.
Mm-hmm. And the other thing too, Tara, that I want to point out, that during October, Tara and I are going to be talking about, we're going to have 4 topics this month about estate planning things like marriage. If you're in a blended family, we're going to talk about guardianship. Tara, you mentioned that word a couple of times today, so we're going to talk about that. So there's going to be a couple of different topics that we talk about throughout this month. So make sure that if you know somebody that's in these kinds of stages of life, that they're considering these things, make sure that they tune in. But otherwise, reach out to Tara at Frame and Frame, and I'd look forward to seeing you guys next time. Tara, thank you again for your time today. We appreciate it, and all your knowledge.
Thank you. This is enjoyable as always.
As always. Thanks, Tara. Take care. Bye, everybody.
Thank you. Bye-bye.